Good afternoon, everybody. Thank you for joining us for our webinar this afternoon on the Employment Rights Bill. My name's Stuart Moore. I'm a director at Plus One Recruitment, for those of you who've never met me before. And I am absolutely delighted to be joined this afternoon again by both Judi McSweeney and Suzie Brightwell of Muse HR. Judi and Suzie joined us earlier in the year for a fascinating webinar all about neurodiversity in the workplace. And I know that this right now is a real hot topic in HR. So again, very, very pleased that so many of you have been able to join us this afternoon. So before we crack on, a little bit of housekeeping. And essentially, as you may well know, this is a 30-minute webinar. And because it's only 30 minutes and the information is quite condensed and we're obviously packing a lot in, it does mean that we won't be able to stop for any questions during the webinar. However, if you've got time at the end, then we will allow a Q&A at the end for anyone who's got any immediate questions and would like to put them to Suzie and Judi. If during the chat, during the webinar, you'd like to ask a question, then I will be manning the chat today. We've given Chatman Dan a day off. So yes, please pop it in the chat. And if I can't answer it, then again, I will pass it on to Judi and Suzie, who can then come back to you offline. So without further ado, I'd like to introduce Judi and Suzie and hand over to them for the webinar.
Thank you very much. So before we kind of get into everybody's favourite subject at the moment of the Employment Rights Bill, Judi and I would just like to say thank you, everybody, for investing their time with us for the next half an hour. As Stuart said, it is going to be jam-packed. We will be sharing a lot of information with you. So hopefully you do have a pen and paper to hand, and then you can make some records. But equally, at the end of the session, we do have a small action plan for everybody as well. So just a quick introduction again to us. So this is Judi and I am Suzie, and we're from a company called Muse HR and Training. We are a HR and training consultancy based in Warwickshire, and ultimately our mission is to make organisations better employers. Now, some of you might be thinking, well, how do we do that? Well, we combine our expert HR support, but we also deliver creative and interactive training, and we like to make learning feel like play. Now, some of our core services are HR services, and this is from day-to-day support to strategic advice. We deliver a lot of training and development programs as well. Some of those details will be at the end of the session. And then also we do some DISC behavioural profiling as well, which really helps teams understand themselves and each other better. So before we get right into the detail of the Employment Rights Bill, we do just want to do a quick disclaimer. So it is important to note that though we are experienced HR professionals, we are not employment lawyers. We will not be offering any legal advice during our session, and we always recommend that you do seek qualified legal counsel if you do have any particular concerns related to employment law. This session is all about helping you understand the changes and supporting your planning as you move forward, but leave the legal print to the experts. So over the next 25 minutes or so, we will be looking at these different aspects. So we'll be looking at the background of the employment law. So going back to 2024, what the bill actually means to businesses. We'll be having a quick look at the implementation roadmap from April 2026. And then Judi will be talking you through some of the key HR reforms, and then equally what employers need to know, and then the final action plan. So kind of a little bit of an interactive exercise. What I'd quite like you to do is if you can either put an emoji or a hands up or a yes in the chat box, how many of you have started reviewing your company documentation, just so we can kind of get a pinpoint of where everybody is at the moment. So I'll just give you a moment.
Yeah, that's good.
Fantastic. No, and that's a really good amount, because ultimately research is showing at the moment that only almost half of businesses surveyed have not started to plan for the implementation of the bill, and only 12% of UK businesses state that they're feeling prepared. Now, some key points, again, just to be aware of and also mindful of. I know I do understand quite a lot of HR professionals are on this webinar, is there is still continuing to be a lack of clarity around the changes and what is going to be coming under the Employment Rights Bill. And also, we are still unsure about some of the major reforms as well that will be included in the bill and basically what they look like. So in terms of the background of the Employment Rights Bill, so let's go back to the beginning. The Employment Rights Bill was Labour's flagship overhaul of the employment law in England, Wales and Scotland. Now, back in the election, the general election last year, Labour made a clear promise to modernise workplaces and basically swing the dial back towards the workers' rights. So when Labour did win the general election in July 2024, they committed to introducing the bill within the first 100 days of office, and they just about made it. On the 10th of October last year, they published what we would probably call as version 1 of the Employment Rights Bill. So since then, the bill has been making its way through Parliament. It's gone through House of Commons, but it's not quite over the finish line yet. It's currently in the House of Lords, where it's still under consideration of amendments, but it is widely expected to receive the royal assent and become law any day now. So really kind of, again, let's go back into what is exactly in it. So the government has described it as the biggest upgrade in employee rights in a generation. However, you can probably see why when you kind of have a look at it, it's around 300 pages long and contains at least 28 major employment reforms. So there's a lot of information in there. But ultimately, the key areas that it's really looking to do is to modernise workplace rights, strengthen protections for workers, and also promote fair pay and flexibility. So kind of what this means for employers, it means that employers, business owners and HR professionals, businesses, we really need to start getting comfortable with the evolving legal landscape. It's going to be busy, it's going to be detailed, and there's definitely going to be some forward planning that we need to think of. So this slide basically shows the implementation roadmap that was published earlier this year. Now, we do understand that if it does receive royal assent in the next few weeks or so, there are some trade union changes that will be happening soon. However, in this session, we're just going to be covering the main things that will be happening from April onwards. So by the start of 2026, 27 tax year, a number of family-friendly and enforcement reforms will be coming into take effect, and Judi will be talking you through those in a moment. And then from the 1st of October 2026, again, we'll be having to look at the statutory duty to take all reasonable steps to prevent sexual harassment, including third parties, which again, you'll note that is a change since last October, when obviously there were just reasonable steps to prevent this. We'll also be looking at the fire and rehire restrictions accompanying the ACAS code. Again, it's tough anyway at the moment, but it's only going to get tougher. And then looking at stronger union access rights and a duty to inform workers of their right to join a union. And then the Employment Tribunal time limit extensions, which again is going to be another change. Now, in 2027, obviously, these are all going to be phased. It's going to be looking at day one unfair dismissal rights with a statutory probation model, which again is very much in contention at the moment. New rules on 0 hours contracts, gender pay gap and menopause action plans, and the expanded pregnancy worker protections and statutory bereavement for pregnancy loss, and flexible work and default rights. So hopefully, again, this roadmap just really shows and illustrates that not everything is coming at once. We do still have time to plan and prepare for these changes. So right now, I'm going to hand you over to Judi, who will be talking you through the key reforms.
Thank you, Susie. Hi, everybody. So when we were asked to look at this, we actually thought it would be really helpful, because if you only think like what we're experiencing from our clients, there's been a lot of confusion about what's happening, when it's happening, and various articles in the news saying this is going to happen, then it's changing. So we thought we'd just kind of take a stopgap and then say, okay, let's have a look at what's happening when, as far as we're aware. So I'm going to touch just on some of the main changes. As Susie said, there are 28 changes, which we haven't got time to go through. So we've kind of focused on the ones that we think most employers are going to need to understand. So the first thing, kind of overriding all of the changes, is the introduction of the Fair Work Agency. Now, this is going to be an administrative agency which is going to report straight into the Business and Trade Department and ultimately the Secretary of State. It's a new employment rights enforcement agency, and what we understand, it's going to be an advisory and enforcement agency that's looking specifically at areas such as holiday pay, leave, and basically making sure that employers are complying with the law. So a different role to the one of ACAS, which guides employers and employees through employment law. This agency will be able to kind of check on what employers are doing and whether they're treating employees fairly, and they will be able to investigate employers suspected of breaking the law and will be able to issue remedies and penalties. One of the things that we have seen is potentially they're just going to be able to drop in and do spot checks on organisations, but again, hopefully that will be clarified through the implementation of the legislation, but it's expected that this is going to come into being next year in 2026. So looking at some of the roadmap which Susie's just shared with us. So in terms of family rights and protection, again, we've highlighted the ones that are more prominent that we think. So from April 26, as you can see there, paternity and unpaid parental leave will become day one rights, whereas at the moment there is qualifying period. In terms of pregnancy and maternity, that's going to roll through in 2027 along with bereavement leave, and there are going to be enhanced protections for maternity, people returning from maternity leave. There will be stronger safeguards from them in terms of protection from dismissal. And in terms of bereavement leave, there's going to be new statutory entitlements covering bereavement for non-parents, i.e. grandparents, and also for earlier pregnancy loss. It's going to be a new entitlement that, again, employers are going to really have to think about. So in terms of what we need to do as employers, it's about reviewing and preparing, looking at our policies and the ones that put your hands up in terms of your prepping for this. Hopefully this is some of the work that you're starting to look at, and also redundancy policies. And you're going to see a common theme throughout these slides about training managers in terms of supporting employees through the changes. In this case, it's about supporting people returning from maternity, and worst case scenario, having to support employees through some form of bereavement leave. In terms of statutory sick pay, so currently employees are only eligible for SSP after the first 3 days of illness, and to qualify they have to earn more than the lower earnings limit. The Department of Work and Pensions have suggested that this change is probably going to be about approximately £15 more for each employee, which doesn't sound a lot, certainly in terms of the work and the effort that's going to have to go into this. But if you employ a large number of people, it could actually have quite an impact on you. So the change the bill is proposing is that all employees will receive SSP from the first full day of sickness absence, and the removal of the lower earnings limit actually means all eligible employees are going to be paid the flat rate or 80% of their weekly earnings. In terms of preparation for this, so payroll systems tend to automatically have checks in there in terms of linking sick pay periods, so understanding exactly when SSP kicks in. So that's obviously going to have to be looked at. Again, reviewing and amending the policies and the handbooks, training our managers in terms of what that might look like, because quite often people get questioned on when do I get my sick pay. Reviewing budgets, again, depending on your workforce, the size of it, you might have to start thinking about planning for looking at your historical sickness records and seeing what impact that would have if everybody got paid from day one. And as we've said, the increase potentially has been estimated at £15 for each employee. Harassment at work is an interesting topic, and one that I'm sure most of you on this call will be aware of. Changed in October last year when there was a move to take reasonable steps to prevent sexual harassment in the workplace. So harassment, as we've put there, it's defined as this unwanted conduct relating to a protected characteristic, and it creates an atmosphere of violating someone's dignity or degrading or humiliating them in the workplace. Sexual harassment fits with that description, except it's unwanted conduct of a sexual nature. Now, we believe that from October 2026, the requirement in the anticipatory duty, which was taking reasonable steps, they're going to add one tiny little word, which is probably going to have a huge impact in all reasonable steps. Again, for those of you who have been working on the change from the sexual harassment, you'll know that there were 8 steps that employers had to take to make sure they were kind of in line with that reasonable steps. But from October 2026, it's likely that it's going to become a requirement rather than a nice to have. So in terms of the Employment Rights Bill, it's going to make employers responsible if employees are harassed by third parties, so other people who come into contact with them during their work. And in terms of these all reasonable steps, we're thinking that regulations are probably going to require employers to train everybody, to make sure that they do the risk assessments, to make sure that managers are trained in supporting employees. So again, getting ahead of the curve on this one, and some of you may have already done that because of the change that was there last year, it's reviewing and checking your policies. Do they include specific reference to sexual harassment? Have you introduced an independent sexual harassment policy, which you can also do, or you can include it in any equality, diversity and inclusivity policies that you have? Conducting those sexual harassment risk assessments, particularly if you've got people who are lone workers, they're seen to be particularly vulnerable. Training managers in their responsibilities, but also the recommendation is that all employees are trained in what sexual harassment is and actually making them aware of where sexual harassment might be happening, but they're not actually realising or appreciating that is what it is. There is also a duty to make sure that people understand what the reporting procedure is. And this isn't just kind of saying to people, follow the grievance process. It's about having a separate reporting procedure. And again, this could become one of the all reasonable steps. So as part of your policy, as part of your reviews, we need to make sure that we've got somewhere in there, a reporting procedure, but also that everyone is trained in terms of what that procedure might look like. So harassment is a big topic on its own. The fire and rehire legislation is an interesting one because although legally people can do that as an employer, it was actually it's always been kind of looked down on as a last-ditch effort of trying to change somebody's terms and conditions and re-engage them on different but generally less favourable terms. So up until the point of the change in this Employment Rights Bill, that has been a legal process. What's changing is that then it will actually become automatically unfair if an employee is dismissed for the two reasons that are shown there. So one is where, as an employer, we've sought to make a restricted variation, and that restriction is going to be things around changing someone's pay, their hours, their holiday, changing shifts, anything that kind of negatively impacts their terms and conditions. Or we're enabling the employer to employ another person. So we've fired them and then rehired them under a varied contract of employment to carry out what was the same duties as previously, but under a restricted variation. So the current law already says that we need to think carefully about going ahead with this, but actually it's only going to get harder if this is something that employers are doing. And we appreciate sometimes it has been the only way to kind of get in a change to a terms and condition of employment, but it's going to be really getting much more difficult. So if you are ever in that position, we definitely recommend that you get some legal advice and support on that one. Unfair dismissal rights. So this one has kind of had a lot of news coverage in terms of day one protection from unfair dismissal. You'll all be aware that currently it's 2 years continuous service to bring a claim of ordinary unfair dismissal. And we normally rely on one of 5 fair reasons, which is the conduct, capability, redundancy, statutory illegality, or some other substantial reason. Now, this point is still under contention because of the day one protection from unfair dismissal. So there may be some changes to this. But as it stands currently, what we understand is going to happen is there will be an introduction of an initial period of employment, an IPE, which basically it's like a probationary period, and the government has indicated currently that's expected to be a 9-month period, might be changed. And during that initial period of employment, there will be a modified dismissal procedure. Again, we're waiting for all of this to be confirmed. Alongside of this, there will be contractual probationary periods. So if this comes into play, employees will have a 9-month probationary period. But alongside of that, the tribunal claim limit is going to be extended to 6 months. And if you've ever kind of, been in a situation where you've dismissed someone, you're waiting those 3 months to make sure they're not going to put a claim in, that's actually potentially going to be extended to 6 months. So there's quite a lot of work needed to be done here in terms of preparation. So definitely looking at our recruitment and onboarding programs, making sure we're recruiting the right people with the right skills, knowledge and experience, and following a fair process when we're recruiting as well. Reviewing and updating our contracts, our staff handbooks, any policies and procedures as well, which link to recruitment and contracts. Reviewing our performance management system. So if there's a 9-month probationary period, making sure we're putting in regular one-to-one spot checks to see how they're getting on. Reviewing our dismissal procedures as well to make sure that we're not kind of breaching any of those. Again, training managers is going to be really important in this area. And finally, reviewing our data protection policies just to make sure that in terms of information that we're sharing or how we're recording employee performance, etc., is all kept within legal requirements. Another contentious one, the 0 hours contracts. Again, depending on what industry you work in, this is a very contentious piece of legislation as well. We're certainly finding from some of the clients that we speak to in the areas of hospitality or seasonal workers, they're very worried about this change coming in. Currently, we can offer 0 hours contracts with no obligation to provide regular work, and we can also offer minimum hours contracts with no obligation to offer more than that minimum. What's going to change potentially is that workers will get reasonable notice of shifts and any changes to them. The new rules will also apply to agency workers, which could be problematic if you rely on those as part of your workforce. It's likely that employers will have a duty to offer 0 hours workers a guaranteed number of hours and information about when they're going to be worked. And again, most people use 0 hour contracts for that flexibility to allow us to have that, switch on, switch off, depending on what the work is. And we will also be required to give reasonable notice of shifts and shift changes to workers on 0 hour contracts. Again, quite a bit of work here needed. We can potentially, there's going to be an opt-out agreement, but again, we'll have to look at in terms of how that's actually going to work. If you are unionised, we'd recommend, having conversations with the union about that and what that might look like. Reviewing any contracts that you currently have in terms of managing variations in your demand and when you need them. Looking at the working hours against the contracts as well. Checking what your record keeping systems are. So are they detailed enough in terms of recording hours to make sure that what we're offering has actually been worked and being able to justify that? And then carrying out regular audits again to make sure that we are not out of line with any of those. And then flexible working, it's another area of contention in terms of currently all employees have the right to request flexible working. That was changed in April 24. Employees are currently able to make 2 flexible working requests in any 12-month period. And at that point, they were no longer required to explain the impact of their request. What's changing is actually that as an employer, you can only refuse it if it is reasonable for them to do so. Reasonable is an interesting word in the world of HR that we work in, because what is reasonable to one person may not be reasonable to another. As an employer, you will need to explain why you are refusing the request for flexible working and why we consider it to be reasonable. And this is, again, it's a really interesting one because for the past 5 years, employees have really been used to more flexible working, being allowed to work from home, hybrid working. I know when we do recruitment, a lot of questions the first people ask is, can I work flexibly? Can I work from home? So actually, if we are then trying to justify why we can't allow that to happen, it's going to have to be a reasonable request. So again, from a manager's perspective, we're going to make sure that they are trained, because I know some managers I've worked with, it's just like, well, I don't want them to work from home. I want them to be in the office because it's more productive. Okay, that's great. But you've got to be able to really think about how you could support that with evidence and articulate your business rationale behind that. So reviewing and updating our flexible or hybrid working policies, or what the company kind of rules are on that. And then again, training managers to not only engage with, but to analyse and respond to those requests in line with what the new statutory requirements are. So I'm going to hand you back to Suzie now. I realise we've just given you a lot of information, but hopefully that's just the headlines that we think are important in terms of you as employers.
No, thank you very much. So basically the other items that the government has also pledged to introduce in terms of employment law reforms won't be happening really until 2027. So businesses with 250 employees or more will be legally obliged to introduce menopause action plans. Now, kind of what we understand really what this means is about creating awareness and also really looking to support individuals who may be having symptoms of menopause or going through menopause. And ultimately, smaller organisations will also be encouraged to follow this, again, to support our employees in the workplace. Now, there's also going to be looking at the ethnicity and disability pay gap reporting requirements for businesses that are 250 or more. So again, it's really understanding your kind of payroll systems, looking at how many people are paid, and then looking at the equal oh, I lost my word. The equality, sorry, of individuals in the workplace. And then again, the contentious of introducing the single worker status, which all workers will then look to be having full employment rights, and then looking at reviewing the current parental leave system, and then examining the carers leave and considering whether it should be paid, because currently it is not. So in terms of the action plan, hopefully throughout our whole slide pack, we have given you things to kind of think about in terms of what is currently going on in terms of employment law, what are the proposed changes, and then also the action plans. But to basically sum it all together, what we're really looking for organisations to do is look at all your company documentation, review it and update it in accordance with kind of what's going on. So that will be including your employment contracts, looking at your employee handbook, and all relevant policies that we have spoken about today. Equally, train your people managers. Now, research has shown that over 82% of people managers are not formally trained in people management. Now, hopefully you've seen with all the changes and the reforms that are going to be happening, actually they all relate to people management activities. So please ensure that your people managers are made aware and trained on the key areas that we've spoken about today. And then ultimately, again, it's about increasing awareness for your employees in your business on policy changes. So not just kind of simply updating the policies and then sending them out on emails. Look at arranging workshops for your employees, managers and leaders. And again, the sexual harassment awareness is an absolute must moving forward. So kind of the next steps that we would like you to think about is kind of if you want more information to see how we can support your businesses with either our HR services or our training services, please book in a 30-minute free consultation, and you can do that through speaking to Stuart. Equally, we're looking to hold a one-day employment course on the 2nd of December. So if you book before the 1st of November, you will receive a 10% discount. And then finally, please talk to us about our people management courses and also our sexual harassment workshops that we carry out for managers and employees. And again, if you book those in the next 7 days, you will receive a special offer. So that is it from us. So thank you so much again for investing half an hour and kind of having all the information thrown at you. And now I'll just kind of pass you back over to Stuart. But thank you so much from Judi and I. It's been an absolute pleasure.
Thank you.
Wow, you did it. The Employment Rights Bill in 30 minutes. Who would have thought? No, absolutely fantastic, guys. A lot of content there. I'm sure you'll all agree. Extremely useful. So again, thank you so much, Suzie and Judi, for that. Yeah, absolutely insightful webinar session. Very interested to hear your point about only 82% of managers have not had any people management training at all. So yeah, I mean, some of my old managers probably fit in that category, I've got to say. But anyway, I won't waffle on. Just to say here, we're next month's webinar will be all about the big recruitment reset. So that is what on earth has gone on this year in the job market and specifically around hiring. But specifically, we're going to be talking about what we think is going to happen next year, where employers went wrong in 2025, but most importantly, what you guys need to do to get it right in 2026. And I know that I think, Suzie, you made the point about getting your hiring right next year is going to be really key when the Employment Rights Bill really comes into effect. So so please stay tuned for that. The information to sign up for that is already on our website. And I think if anyone has got a little bit of time on their hands, we're just about reaching our 30-minute limit, but we're happy to run over if anybody would like to ask any questions. You should be able to unmute yourself, or I can unmute you. But what we usually do is if you put up your virtual hand, then we will try and get round to as many people as possible if you'd like to ask a question of Suzie or Judi. And just also to say that this has been such a big topic that I will be making the effort to actually make contact with everybody who's attended this webinar at some point over the next couple of weeks. If you don't want me to contact you, don't worry, I won't feel offended. Just put no thanks in the chat and I will leave you alone. But yeah, that would be great, and we'll follow up with everybody in the next couple of weeks. So I think we've got a couple of raised hands. Let's see who we've got. Jen, you've got a question for the guys?
Yes, I have. We have a company sick pay scheme that pays 25 days pay at basic pay in a rolling 12-month period. But to deter the kind of duvet days, don't want to go to work on a Monday, we've followed the government SSP guidelines, and we have 3 waiting days for our company sick pay scheme. So if someone's off ill for a week, the first 3 days are unpaid, and then they'd have 2 days at basic pay. With the SSP abolishment of the 3 waiting days, would that affect a company sick pay scheme as it's more generous than the government SSP?
Do you know what? I think a lot of the changes that have been announced are potentially, it's going to be one of those, we'll need a tribunal case to thrash this out, because I don't think that will have been thought about, and it's a great question. My initial thought would be it only relates to statutory sick pay. So you would have to pay statutory sick pay for the first 3 days, but your company scheme is discretionary, and therefore you could do what you want with that. But again, it's an interesting, I mean, I think you've just got to try and apply some common sense to these things until they get tried and tested. But it's a great question.
Thank you.
Thank you.
No, thank you. And you won't be the only one thinking it as well.
We've got another question from, I think it's Michelle. Hopefully I'm pronouncing that correctly. Oh, you're on mute. Let's just unmute you.
You got me now?
Yep, there we go.
Yes.
You're
okay,
on.
so once again, thank you very much for the presentation. Just really key highlights over when you mentioned the ethnicity and the disability pay gap reporting requirements, from the point of view of getting the data and any advice, if you like, that you would have in terms of managing this.
So I think really it's about looking at the recruitment onboarding process. So a lot of businesses, especially the clients I work with, as part of the paperwork, they do the equal opportunities monitoring form, which again remains anonymous, but it's about having a system in place to be able to look at that, which will then help which will then support kind of looking at the detail in terms of where the differences may be. And then I think in terms of, again, looking at the pay gap, it's about, again, when you are doing your recruitment procedures, it's making sure that your salary bands are fitting in with kind of the market rates, etc. But then again, looking at individuals' contracts. So I think it will really be looking at 2 different systems to analyze that data for you.
Okay, and is there an ownership on the employees to provide the data, or only from the point of view that if you get the data, if you see what I mean, because they've been very open?
Yeah.
Any views on that one?
I can't provide views, especially putting me on the spot. So in terms of kind of the equal opportunities monitoring form, now currently that's not compulsory. Employees don't have to complete them. It's almost like a best practice. Again, thinking about my career, there hasn't really been too many employees who say I won't do it. So I think you've really just got to kind of manage the data that you receive. But with the salary information, that should already be at hand anyway.
Yeah. Okay. Thank you very much indeed.
No problem. Thank you.
Thank you.
Thanks very much for that question. Does anybody else have any other questions for Judi and Suzie before we finish the webinar? Just to say, I did pop this in the chat, but the webinar has been recorded, so we'll be popping that video for you to stream later on this afternoon on our YouTube channel, and I will be sending out an email with that link on before the end of the day, so you can play this back to your heart's content to help absorb some of the information, because I appreciate there was a lot of content here. Okay, so yeah, final ask. Anybody got any other questions before we wrap up for today?
No.
Okay, fantastic. Well, thank you again, Judi and Suzie of Muse HR, for being fantastic speakers today. If you're interested in our next webinar on the 19th of November, please go to the website. It's sure going to be an interesting topic talking about next year. And yeah, have a great rest of your day, and thanks again for attending.
Thank you.
Thank you.
Thank you for the invitation. Thank you.
Thank you.
Thank you.